So you might have a wonderful caregiver and you want to leave money to them when you die. But someone mentioned that you might need some extra paperwork or you might need to visit an attorney to do this. You might even need something called a certification of independent review. What's that? Why might you need one? In this video, I cover what this is and how to get it done. So in California, we worry that caregivers might take advantage of vulnerable elderly people that they take care of. Maybe they could threaten to not take care of that elderly person or to isolate them unless that person gives them money now or upon their death. Unfortunately, it's happened before. So in California, we passed a law stating that any gift or bequest through a trust or a will made to certain categories of people are presumed to be made under undue influence. That means somebody's twisting your arm under the table or something like that. And you'd have to overcome that presumption in order to successfully make that gift or bequest. So there's a presumption that when a gift is made from a dependent adult to certain categories of people, it could be presumed undue influence. So what's a dependent adult? That's a person who's disabled or they're age 65 and older and they're not able to provide for their own physical health, food, clothing, or shelter needs, or they have difficulty in managing their financial assets or resisting fraud or undue influence. So which categories of people would raise this presumption of undue influence? First of all, the person who drafted the trust. So if I draft a trust for an elderly person and I have them give money to me, yikes, that's presumed undue influence, and you could understand why. Also, someone who's in a fiduciary financial relationship with them, like a financial advisor. If somebody gives money to their financial advisor, that's presumed undue influence. And finally, gifts to caregivers of dependent adults by that dependent adult is considered obtained by fraud or undue influence. And you can only overcome that presumption of fraud with clear and convincing evidence that the gift was not a product of fraud or undue influence. That's a really high standard to prove. So let's say that you're over age 65 and your health is declining and you have a caregiver that you rely on to help you with many of your needs. And let's say you really, really like your caregiver. They've taken care of you for a while and you want to thank them by leaving something to them in their trust. But this gift would be presumed fraud or undue influence under the California statute. What should you do? How can you overcome this presumption? So the Probate Code, which is the set of statutes in California that describes how a trust and probate should be run, they provide a way. They say that you as the dependent adult can work with a second attorney called the independent attorney to confirm what you actually want to give to the caregiver. This is a separate meeting than with the first attorney who drafted your trust. Note that the independent attorney can't have any legal, business, or professional relationship with the person receiving the gift, and they can't receive any benefit, like if they're acting as trustee of that person's trust. This makes sense. So what does the independent attorney do? Well, they would meet alone with you. They would review the legal document with you to make sure that you understand it. That would be the trust and the gift, and that you understand that the trust becomes irrevocable when you die, and that you understand the consequences of the gift. This might mean that if you have children or other heirs, that they might be receiving less or even nothing at all as a consequence of you giving money to the caregiver, and that they might actually get upset by that. And then they'll also ask you a lot of questions to make sure that there's no undue influence or fraud that's being exerted by that caregiver. So the independent attorney should take careful notes of that conversation. They can also interview third parties like family members and friends to make sure that there's no fraud. Then finally, that independent attorney would fill out and sign what's called a certificate of independent review. So let's go over one together. So this is a basic outline. Typically an attorney would fill out more than this, but it says I, attorney's name. So this is the second attorney, the independent attorney, who's kind of doing the overseeing, the look over, have reviewed the blank, the name of the trust, and counseled my client, blank, that's the dependent adult that the independent attorney met with, on the nature of the transfer or transfers of property to, and then that's the potentially, it says the potentially disqualified person, that's the caregiver. So these are gifts to the caregiver. So it reviewed the gifts and their nature the gifts to the caregiver contained in that trust instrument. I'm in a position to advise my client impartially on these gifts, and I conclude that these gifts that otherwise would be invalid under the probate code are valid because such transfers are not the product of fraud, menace, duress, or undue influence. And then they sign and date it. Now, this is not a panacea, all right? This can overcome the presumption of undue influence or fraud, but it doesn't mean that there's no fraud involved. It's just evidence that an attorney didn't think that there's fraud involved. So an unhappy family member can still challenge the certificate of independent review. And that's why an attorney typically will take a lot of notes to support what they say on that certificate. Now, for that reason, I suggest that you work with an attorney if this is your issue. You work with an independent attorney who does this a lot, who prepares a lot of certificates of independent review regularly. They know what to look for, what to put in them, what will pass muster with the court system. Now, I recognize that this process can seem pretty cumbersome and expensive. I mean, you have to meet with not just one, but two attorneys. Most people don't even want to meet with one attorney, right? But this is a way to avoid fights and debates upon your death. So if you think you have a family member who's going to debate your gift to a caregiver, you gotta get one of these. And even if not, you should get one because that caregiver is otherwise a disqualified person. And that's really the best way to secure a gift to a person who may have provided excellent, amazing care for you. Now, here at Cookman Law, we don't practice elder law and we don't prepare certificates of independent review, but we're happy to provide you recommendations of some attorneys who do. And if you're curious about the estate tax consequences of making gifts upon your death, please check out my video about estate taxes, and I'll see you over there.
Did you know that my mom has a monthly newsletter? Subscribe by clicking below.